Welcome to the Agent of Wealth podcast with Marc Bautis from Bautis Financial. In this podcast, Marc helps guide you towards financial freedom, ensure you never run out of money, and create a balance in life that prioritizes what is most important to you. Join us for this journey as Marc draws from years of expertise and guest experts to solve the multiple wealth building challenges involved in your financial life.
Welcome back to the Agent of Wealth. This is your host, Marc Bautis. On today's show, I brought on a special guest, John K. Ross. John's the founder of Ross and Shoalmire Elder Law Attorneys, the largest boutique estate planning and asset protection law firm in Texas. John's a nationally recognized expert in estate planning, asset protection, and taxation with over 20 years of law practice. He's also published multiple articles for organizations like the University of Texas Law School and the National Academy of Elder Law Attorneys, is the publisher of Aging Insight magazine, and is a co-host of the Big Picture Retirement podcast. John, welcome to the show.
Yeah, I'm glad to be here.
So yeah, thanks for being on. I'm looking forward to talking about estate planning. As a financial planner, I think the two things that people put off or delay most are kind of finding out where their money's going, a budget, spending plan, and estate planning.
No question about it. It's really easy to just work, build, and then put off those two things, right? Nobody wants to talk about getting old and dying, and it's not fun stuff.
Right.
But super important.
Oh, of course. So I guess maybe to get started, what are the main elements of an estate plan? What goes into it?
That's a good question, because this is probably a pretty common misunderstanding. When I first started, when I was a little baby lawyer and started out doing this sort of thing, I noticed that people would go and they would visit with their financial advisor, for example, right? And they would get them a financial plan to get from retirement to the grave. And then they would come over to me and they would say, okay, John, we need to plan for what happens when we die, right? They want to get a will or they want to do something, right? They've got the financial, their retirement income, they've got the Social Security picked out and all of that sort of stuff. But the first element of a good estate plan is going to be a plan for incapacity. If you hit age 80, 85, your statistical likelihood of being incapacitated prior to death is about 90%. So it's going to happen. And, from a very basic standpoint, if you've ever tried to call the phone company and your name's not the one on the account,
it can be difficult.
Yeah. I have to drag my wife to Verizon if I want to get an upgraded cell phone, right? Because she's the one that set up the account. And while that may be annoying right now, if my wife has a stroke and she's never going to speak again, I'm stuck with a Samsung Galaxy S10 forever at that point.
Yeah.
So, having powers of attorney, so a durable power of attorney for financial, a medical power of attorney, so somebody can make medical decisions, HIPAA authorizations so that people can access your medical information if they need to, find out how you're doing, and a living will or directive to physicians that says what you want for end of life care. Do you want to be kept on machines if you're never coming back off of them, that sort of thing. People will often ask me, they'll say, John, how old do I need to be to see an elder law attorney? Well, you need to be 18. I make my kids sign those 4 documents the day they turn 18. You don't get to pick when you become incapacitated, right?
Right.
And given the way my kids drove cars when they were teenagers, the risk of incapacity was seriously high. So yeah, those 4 things, that's kind of the basics. But then, the bigger issue is the cost of care.
Right.
That can take a real gut punch to your financial plan if you were not calculating in how you're going to pay, $6,000 to $10,000 a month for in-home care providers or nursing home providers. And I think most financial advisors would be saying, yeah, okay, when you're in that pre-retirement age, 55, 60, let's talk about long-term care insurance. Let's look at the different options, traditional versus hybrid plans, and let's have that conversation. You're in the financial advisory business. You probably had those conversations. Well, there's a reason why only 5% of the population has long-term care insurance, right? You just can't hardly get people to want to insure themselves for that sort of thing.
Yeah. Going back to that original of people just delay the whole estate planning concept, that's one part of it too, is people don't like thinking about it. And there's, I think, problems with the long-term care insurance industry in terms of pricing rises, what does it cover?
No question.
So when you combine all that type of stuff, then yeah, it becomes difficult to get people to move forward on it.
Right. And so at that point, then, if you don't have long-term care insurance, then you really only have two options. You're either going to private pay for care, which if you're blessed with a lot of resources, great. But you figure the average length of stay in a nursing home, if you're a man, 2.5 years. If you're a woman, it's 3.5 years. So for a married couple, you're talking 5 to 6 years potentially. And, I'm talking Texas rates at $200 a day, give or take, for nursing home type care. That's $6,000 a month. That's a lot of money.
Yeah.
You get up, you're in New Jersey, right? I mean, you could probably come close to doubling that cost if you're in a major metropolitan area, if you're in a Seattle or a Los Angeles or a New York or something like that. So private pay, that's one option. And then the only other option would be the need-based care, something like Medicaid. And the problem is those rules are terribly complicated. They're very restrictive. And yet, you can have people that maybe there's some planning they could do on the front end that would preserve some of their assets so that maybe they don't have to go all the way down to broke before they're eligible for something like, long-term care. I'm in a very rural area primarily. I see a lot of farmers. And so they may not have a lot of cash money, and yet they may still have a net worth in the $3, $4, $5 million range. Right? But it's pasture land and half-grown pine trees. Well, here they can't qualify for Medicaid because of the value of these assets, and yet they have no cash to pay for their care. That's a real pickle. You start looking in the bigger cities, and you'll see almost the same thing because of the highly appreciated real estate. You bought that little townhome on Staten Island in 1968. What's that thing worth today?
Yeah.
Right? And so maybe you need to look at those assets and say, okay, we need a plan for incapacity. How are we going to pay for it? First element is you need to be able to answer that question. How am I going to pay for the long-term care? And there can be a significant estate planning element to that for most people.
Is there like a threshold where someone would say, or would someone make that decision and say, I can self-insure or self-pay for this, or I should put the risk on the insurer, or I should take out a long-term care insurance policy, just for that example?
It depends on a couple of things. So one is going to be geographic location. $1 million in an IRA in Texarkana, Texas, you're not going to go broke. That's going to be more than enough money to get you through your years from a long-term care standpoint. Whereas if you're in Boston, that same $1 million IRA, I think the last time I looked, the average cost of nursing home care in Boston was like almost $400 and something a day. Well, at $12,000 or $15,000 a month, you can burn $1 million in no time. So you've got that kind of geographical issue first. Because in Texarkana, I might say, oh yeah, in fact, I just visited with somebody yesterday and they got about 1.3 in an IRA and then some other cash asset. And I was like, oh, well, y'all will probably be able to self-insure. They were already in their 70s, so there's no way they're going to get any long-term care insurance at this age anyway. And so I was like, yeah, y'all are probably fine. On the other hand, if I was having that same conversation with somebody in Boston, I might be like, maybe we need to look at some other options. Then the other thing is the nature of the assets, right? If we're talking about $1 million worth of IRA money, well, you can spend that. If you're talking about $1 million worth of rental properties, well, you can't spend that. And if they're not kicking out enough rental income to cover the cost of your care, then you're going to have a problem, because you don't want to have to be in a situation where you're doing a fire sale of your rental properties to generate cash to pay for long-term care. That's going to be a disaster.
So what do you do in that case? Because you're kind of balancing a couple of things, right? You're trying to do what you need to do for yourself for potentially what might come down the road, but also, and I don't know if does any of those choices conflict with what's the best thing to do as part of like the estate plan and what happens after someone passes away and how those assets get transferred to heirs. Do any of those decisions conflict each other, and how does someone decide what's best to do in that case?
Yeah, it does. And I will say that generally speaking, when I'm talking to people, they will have one of three major concerns typically. One, they don't want to be a burden on their friends and family. Two, I have some people that just absolutely do not ever want to see themselves in a nursing home. And then I have three, people that just don't want to go broke, trying to do the first two things, right? And so there's often a priority in there for each individual. I've had some folks that say, look, I don't care if I spend every penny of my own money on my care. just as long as I'm getting the kind of care that I want. Right. So we're going to look at that one person slightly differently than maybe the person that says, look, the most important thing to me in the whole world is that I leave behind this money or these assets for my kids. And I'm willing to go to the nursing home. I'm willing to do whatever needs to be done. I'm willing to protect my assets, whatever I need to do, just so long as we preserve as much of this for the next generation. And that's going to dictate kind of some of the ways that I'm looking at the estate planning, because I may be saying, okay, well, look, we need to shield this farm or these rental properties. Let's put those in a trust where the assets would not count towards your eligibility for Medicaid if and when we get to that period of life, right? And we're doing that so that at least Medicaid would be an option to pay for their care, and we can preserve the value of those assets if that's an important factor for them.
Would they still have access to those assets? So in the case where it comes down to it and it's that decision of Medicaid or, let's say, paying for their own care, and they just come and say, you know what, I don't want to go the Medicaid route. I want to whatever my standard of care they're looking for. Would they then be able to go back and either use some of the value of those assets or use the income that those assets are generating to pay for their care in that case? Or was it once it gets in the trust, it's gone and they have no access to it?
Generally, yes, they would have access to it either directly or indirectly. So, for example, one of the types of trust that we'll use is, for example, I create the trust and I'm entitled to as much or all of the income from the trust, but not the principal. The example being like if there's a CD in the trust, I can get the interest off the CD, but I'm not permitted to distribute the CD itself back to myself. What that does is that shields the value of the CD, but it still gives me the access to the interest that's kicking off of it. Mm-hmm. But here's the thing. Let's say that I say, okay, well, I'm creating this trust and I'm entitled to the income, but not the principal. But I'm going to make you the beneficiary of the principal. Okay, so we get to a point and I say, you know what? The income off of this trust is just not going to be sufficient. I would like some of that principal. Well, I can't distribute it to myself. That violates the terms of the trust. But there's nothing stopping me from distributing it to you. And then, of course, there's nothing stopping you from giving it back to me. And so even there, I can create kind of almost a back door to accessing the principal. And again, usually this would be, the parent and their two kids or something like that, right? Where we've got this kind of unified family dynamic. Everybody knows what's going on, and this is the plan. And that's just one example. There are certainly lots of others out there. But yeah, so again, you're trying to figure out what's best for that particular person. What are their circumstances? Sometimes people say, look, I don't want control over these assets. I saw how, my mother got Alzheimer's and as her mental health declined, she gave everything off to scammers and was tricked into doing things. And so I don't want to put myself in that position. So I'm going to try to protect myself from myself. So again, it just kind of depends on everybody.
Mm-hmm. And what about the taxation aspect of it? I know it depends on where someone is in their financial plan or their financial standing, but I do see that as another concern of people is whatever they do, they want to do it in the most tax efficient way possible.
Absolutely. And I would say that anybody that is, you're looking at doing estate planning, much like it's hard to judge financial advisors when you first meet them, is this person really have my best interests in mind? It takes a little while to kind of get to know them. The same thing when it comes to attorneys. But a good attorney in estate planning is also going to have a pretty deep knowledge of taxation. You can't do one without the other, or you're going to screw it up for the people. When it comes to things like trusts, there's actually several different ways that a trust could be taxed, and there are pros and cons to all of those. But for example, for the average middle class type person, if they're using a trust, they're going to want this trust to be taxed as what we would call a grantor trust, meaning that it's taxed as if they still own the assets. Even if they don't have a beneficial interest in the trust, it could still be taxed as if they own the assets. That seniors in the lower tax bracket, typically, they want those assets to be taxed as if they still own it. Avoid even having a separate tax return. They can use their Social Security number for the trust and all of that sort of stuff. So that's going to be a very simple and easy and efficient form of taxation. On the other hand, I have clients, for example, let's say they live in California. Their investment income alone puts them in the highest tax bracket. California has a 14% state income tax.
New Jersey's not that far behind, but yeah.
Right. So one of the things that a lot of them are doing is they're going to create a trust that is taxed as a trust. So the trust is a taxable entity. But then they're going to base that trust out of Nevada, right? Then they move their income producing investment assets into this trust that's governed under the laws of Nevada. It's out of California now. It's now in Nevada. And because of that, they're still paying the federal tax. The trust is paying federal tax on that income, but Nevada doesn't have a state income tax. And so just by changing the way the trust was structured, using different states' laws, they've just gotten themselves out of 14% California income tax. Now, obviously, that's going to be typically a very wealthy person, right? They're going to have a lot of investment income from that sort of thing. So again, like you said, you're looking at that person's situation, but you do absolutely want to make sure you're covering the tax issues in all of this.
Two questions about the trust and taxes. Now, you mentioned the grantor trust. I know a lot of people like the concept of the step up in basis on an asset when someone passes away. Do they give that up? Some people have like these real estate or even stock holdings that they've had for years and have a big gain inside it. Do they give that up once it goes into a grantor or other types of trust? Or is it something that the beneficiary can basically take advantage of, that step up in basis when whoever they're inheriting it from passes away?
Yeah, so when you're designing the trust, that is one of the issues that you want to be very careful about. Again, depending on the terminology of the trust and the language in the trust, the assets in the trust can either be included in the gross estate of the deceased person, in which case they get a step up in basis, or not, in which case they would not get a step up in basis. And it often depends. Mostly with what I see, I have people that do not have a taxable estate, right? So the value of their total estate is less than the $12.9 million under the current law. And yet they have homes or farms or rental properties. They have these appreciated assets. And so the most tax benefit to them is going to be to get that step up in basis at the date of death. So we're making sure that the provisions in that trust are going to get that step up in basis so that when they die, kids inherit the house, they can turn around, sell that house. That's a tax-free sale because they got the step up in basis at the date of death. But on the other hand, I may have clients that do have a taxable estate, and we're trying to put assets in trust so that they will not be included in their gross estate to get those assets out of the death tax, right? So It's all about the structure.
We're talking about trusts here, but a lot of people's thinking of estate planning is they centered around the will. How does someone decide their estate is simple enough and a will do, or they may need something more complicated and may need to go the trust route?
Yeah, I would say probably one of the most common questions that I get is, John, do I do a will or do I do a trust? And most people are surprised by my answer. My answer is typically both or neither. And then they're looking at me and they're totally confused. They're like, okay, that doesn't make any sense at all. The first thing is you have to understand that when you die, some assets could go through the probate process and some assets would pass automatically. And often the best example would be if I were to name you as the beneficiary on my life insurance. On the policy, you're named as the beneficiary. I die. All you've got to do is call the insurance company up, show them my death certificate and your driver's license. They're going to write you a check and off you go. That's a good example of a non-probate transfer. Passed to you according to the contract. Same thing with my IRA, for example. In many states, you can name a beneficiary on real estate, for example. What they call beneficiary deeds or transfer on death deeds. There's various names depending on which state you live in. And so I could have somebody that, they come to me and they say, John, I think I need a will. Well, we look at it. They've got a small house. They've got an IRA. They've got a bank account. Well, name pay on death beneficiaries on the bank account. Name beneficiaries on the IRA. Let's do a transfer on death deed so that passes automatically at death. Well, at that point, what is there to will to anybody, right? Your big brown furniture that nobody wants anyway, and your collection of Hummel figurines, right? Well, if that stuff matters to you, just get a piece of paper and write out who you want to get it, right? But that's kind of the case of a neither, right? That person didn't need either a will or a trust. What they needed was to create non-probate transfers on each individual asset. But often people have more complex estates. Maybe they have larger assets, larger in value, or just more. Often with those, I still want to create a non-probate transfer, but I want to do it in almost a universal way, right? Without having to go name every single bank And I want to be able to provide for contingencies, because it's one thing if I name you as the beneficiary on my life insurance, but then what happens if you die before me? I need to go back to that life insurance company and name a new one, which is all fine and dandy unless I have Alzheimer's, and now we've got a whole nother problem. So the alternative, but still creating a non-probate transfer, would be to use something like a trust. Assets that are in a trust pass according to the terms of the trust. So I usually use the example, it's kind of like a bucket. And now we can put all your stuff in the bucket. We can deed your home to the trust. We can your real estate to the trust. We can change your bank accounts to the trust. We can designate that trust as the beneficiary on life insurance and things like that. And assets that are in the trust are going to pass according to the trust. So I die, the trust just keeps going for my wife. When she dies, the trust splits between our 4 ungrateful children and they get to go party like rock stars, right?
On that, if someone came and said, well, I have these assets and I have my children, I don't want them just inheriting a lump sum of everything. And I know a trust, you can specify the terms or conditions that they have access to those assets. Is there any way to do that in a will, or is that something that you would need a trust for?
Pretty much anything you could do in a trust, you could do in a will. So, for example, tax planning, you can provide for your beneficiaries, including protecting those beneficiaries. So pretty much anything you can do in a trust, you could probably do in a will, at least as far as the beneficiaries. The biggest difference between the two is with the will, you're putting what you want to happen in writing, which is quite easy on the front end. But no will is valid in any state in the United States until that will has been admitted to a court after your death. And there's going to be a process involved there, right? You're going to die. Somebody's going to have to take that will. They're going to hire an attorney. That attorney's going to file the will with the court. Depending on your court system and where you live, maybe a couple of weeks later, maybe a couple of months later, you're going to get appointed as the executor. You're going to have duties from that point. File an inventory of the estate, publish notice to creditors. There's typically a waiting period where you have to wait for creditors to file claims against the estate. Then you pay off the creditors, you pay the lawyer, you pay the court costs. And once you're done with all of that, you can now start following the terms of the will as far as setting up trust for beneficiaries or things like that, right? But that's a lot of process on the back end, and it's typically quite a bit of cost on the back end. And again, depending on where you live, that's going to vary. California and New York, for example, both kind of notorious for their probate processes being quite a pain in the rear. Florida as well. I think that may just be because of all the New York people that moved to Florida.
It's quite possible, yeah.
Right. But even in Texas, where we have a relatively, Texas and Arkansas both a relatively simple probate process, but it's still a process. And it's still something that I tell people, look, this is going to take 4 to 6 months and we're going to go through the motions, right? So, but yeah, to your question, yes, you could do most of the same stuff in one or the other, but doing it in the trust, you're setting everything up while you're alive, while you have the time and the convenience, and you can get all of these things in place on the front end. And then that trust is just going to govern at your death. There's no going to court. There's no delay in time. If it says everything goes to the kids, it goes to the kids. And so back to it, we started saying, step 1 was have a plan for incapacity. Step 2, to me, of any good estate plan is having a plan for a non-probate transfer of your assets. Whether that's a trust or whether that's just individually designating beneficiaries on everything. But one way or the other, usually passing assets by will is going to be the most cumbersome, time-consuming, and expensive way to do it.
Is there any reason to actually have something go through probate that you can think of, or is it you want to avoid probate when you can?
Well, I met a lady here a while back, and she's what we would call a senior orphan. She's single. She has no kids. She never had any children. She's leaving most of her estate to charity. And, honestly, she really doesn't care what the process is after her death, right? And she would, frankly, rather the executor be the one that does the work. If that costs some money, if it takes some time, who really cares? It's all ultimately going to charity. And so, yeah, for her, it actually did make sense that the primary vehicle was a will. And she wasn't creating anything complicated. These were just outright bequests in the will to various charities. That works out real good. So there are some of those situations. And I will say, even in my own family, I did some estate planning for my grandfather. And at the time, he was already either in his late 80s or early 90s. I don't recall which exactly when we did the will, but I did a will for him. But part of my reasoning at that time was, frankly, it was going to be easier on him for my dad and me to do the work after he died than it was for this 90-year-old man to try to do the work now. So there is some age and stage. There are some circumstances where the will may be the appropriate vehicle. But I think for most people, creating that non-probate transfer is going to be the way to go.
Now, I'll have some people come and they'll say, I want a will because they have minor children. They want to name a guardian of their minor children. Is there some place outside a will that they can do that?
Yeah, and in fact, I would generally recommend against designating a guardian in a will, and instead doing that as a standalone document, a designation of guardian for, minor children. And the reason being is that the will in and of itself is not a valid document until it's been admitted to a court. So that also means that your designation of guardian within that will is not a valid document until it's been admitted to a court. Well, we don't really want a delay in time between your death and people being able to step in and take care of little Timmy. So doing a declaration of guardian as a standalone document, to me, usually makes a lot more sense. It's very clear. It's right there. Bam, you've got it. That is going to vary somewhat from state to state. If, there may be a particular law in Idaho, for example. I don't know. I'm just throwing that out there that says, it needs to be in the will. Okay, fine. But I prefer doing it as a standalone document for that very reason, right? What happens if you've put that in the will, now somebody's contesting the will based on a financial reason, right? They're saying, I thought I was supposed to get the house, and so I'm going to contest this will and say that you were incompetent when you made the will, or that somebody unduly influenced you, right? Well, now you're going to have a 12-month contested probate case over the validity of the will. Meanwhile, that declaration of guardian in the will is still also now being litigated indirectly, because if the will's invalid, well, then that provision in the will is invalid. So yeah, I like them as a separate standalone document.
We talked about a lot of different documents, right? Everything from healthcare directors, power of attorneys, trust, wills, the guardian director. Is an attorney needed for all these? Some of these? None of these? How should someone approach, should it just be in a bundle? Let's go to an attorney and take care of all these at once? Or is it, okay, I can put my will or power of attorney or even trust together without an attorney?
So I would say if you're talking about some relatively basic stuff. So for example, your kid's turning 18, you're sending them off to Vanderbilt or wherever you want them to go to college. And you're thinking, well, you know what? Now that they're 18, you no longer have the legal authority to make medical decisions for them. So you should probably have them do a medical power of attorney. Well, there's actually a federal law that says every hospital in the United States is required to provide you a form for a medical power of attorney free of charge. Right? So you walk into the hospital, you say, hey, I would like to get a copy of a form for a medical power of attorney. They're going to hand you one. You get your kid to sign it. You get it either witnessed or notarized as required by your state. And now you've got a document that's going to allow you to make medical decisions if your kid gets into a bad accident when they're down there in Vanderbilt, right? You didn't need an attorney for that. On the other hand, if you're talking about yourself and you're planning for this incapacity and you're looking at maybe doing a trust, maybe even doing a will, doing some powers of attorney, I would highly suggest the guidance of somebody that actually does this all the time. Here's my best example. I have an attorney that works for me, and he was a personal injury attorney for the first 10 years of his law practice. So he was an ambulance chaser out there. And then I finally brought him over to the good side. And he had worked with me for about 6 months. I had him following me around and kind of working with my clients and showing him how to do things. And I remember at one point he said, I just looked back at the will I had done for myself, and I am shocked at how bad it is.
Yeah.
So this is a practicing attorney with 10 years of experience, just not in this field. But I mean, he still went to law school. He's got a law license. And he would be the first one to tell you that he screwed up his own planning based on his lack of knowledge. Well, if that's the case, think about the person that's just a They're an engineer, they're an account executive, right? You're just an average Joe out there. You don't have 20 years of dealing with families and all of their intricacies and the knowledge of all the rules and regulations and stuff that are out there. You're likely to screw it up if you try to DIY this.
Yeah, no, that makes sense. On that topic of the attorney looking at his plan, is there something that should trigger, okay, I need to go and update my estate plan?
Certainly any major change in the family dynamics. And by that, I would mean if there's a death, if there's a catastrophic illness, if there are divorces, or maybe you've got a child that's gotten into some criminal trouble, or they're in a bad marriage, or they've got a bunch of creditors, or these kind of big family issues that they're stressing everybody out. That may be a good time to go back and visit with somebody and say, hey, you know what? I've left everything to my 3 kids, but my son, him and his wife, they're just not getting along. That's likely to end in divorce. Is there anything we need to think about?
Yeah.
And you don't have to know the answer to it, right? You're not walking into the attorney's office to say, I want you to do this because of my son, right? You're saying, is there an issue that we need to address? Is there a way we can address this issue? And again, they should have an answer to that, because that's something we see all the time, are these sort of issues. So certainly if there's any major change. Beyond that, how often you should go back, some of that is age and stage. Obviously, if you're 30, the difference between the plan you did at 30 and the plan you did at 35, unlikely to need any changes. But the plan you did at 70 and 75, well, that's a bigger deal. At that point, you probably have a lot more in assets.
Yeah. You've
got a much more diverse situation, and your age and health are probably changing at a much more rapid pace. And there's going to be laws. What are we? We're 2 years into the Secure Act and the change in inherited IRA. That was the biggest change to inherited IRA law that we've seen in decades, right? And yet, I'm still the first one. I just talked to somebody yesterday and I said, well, you've got this IRA and, your kids are going to have to pay taxes on that within 10 years after your death. And they were like, really? I thought they can roll that over. Well, that's what I did when my parents died. I just rolled their IRA over. I'm like, yeah, well, they took that away from you 3 years ago, right?
Yeah.
But here's, that's the kind of thing that if you're not keeping up with all of how could you really keep up with all the law changes that impact this? That's one of those things where if you're checking back in with that attorney, even if it's something as simple as an email, that's what I tell my clients. I'm like, just shoot me an email once a year. I can look back, I can look at my notes, and I can say, oh, this person, they have a big IRA. You know what? I email them back and say, hey, you know what? We may need to readdress some issues because of the Secure Act. Let's see if we can mitigate the tax consequences to your kids when they inherit this big IRA. And again, those are going to be typically your people that are in that 65 and plus range. They probably need to be checking in much like you would with your health, right? You go in, you get a physical. They poke you, they make you run on the treadmill, they do the things, right? The doctor comes back, says you're healthy. It doesn't mean you're healthy next year. And so what do? The doctor would tell you, come back next year and get another physical. And if you do that regularly, you might just catch something before it becomes such a big problem that it can't be fixed.
We started this off talking a little bit about resistance people have to doing estate planning. How do you enhance the chance of success when a lot of times it's driven by the child who's looking out for the parent and wants to push it, and maybe there's some resistance on the parent side of doing anything or addressing it?
Most of the time, I will say this is a problem with the kids' approach. I mentioned earlier, I've got 4 kids. They're all adults. My youngest is 20. But from my perspective, they're all still kind of morons. And I've got one in law school. I've got one getting a master's degree in material science engineering. I've got one that's a staff sergeant in the Air Force and one that's a dog groomer. These are all great kids. They're smart. They're employed. They're doing their things. But I'm not terribly interested in their opinions. And what's funny is I see that now. I see this dynamic now. But then I think about the fact, okay, I'm a accountant, lawyer. I can practice in front of the U.S. tax court. My parents won't let me do their tax return.
Yeah.
Why? Because to them, I'm still that dumb kid, right? And they don't want to take advice from me. That's a weird dynamic. I think a lot of times as the children, when we're talking to our parents, we see ourselves as the mature adults, and we just don't think about the fact that our parents don't. They still see us as a 10-year-old that was trying to steal cookies out of the kitchen. So I think one of the things is your approach, right? If you're saying, Mom and Dad, I think y'all need to do this because I'm mature and smart and I know what's best for you, you're going to get nowhere with that. Everybody has seen these situations go bad in other people's families. You have a friend, a neighbor, somebody in church, somewhere, and they've told you, oh yeah, when my mom died, brothers and sisters, they got into a big fight, or they had this lawyer and it cost a whole bunch of money and it was all of this, blah, 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 right? And also I would go back to those three things that I mentioned earlier, the desire not to be a burden on others, the desire not to be in a nursing home, and the desire to not go broke paying for the first two, right? Say, hey, do y'all remember Sally, that girl I went to high school with? I was talking to her the other day and she was telling me about, man, this train wreck with her mom and mom got Alzheimer's and man, she spent all of her money and then ended up in a nursing home. What would y'all want in that situation? And maybe try to feel them out a little bit. And are they saying, well, I dang sure don't want to go to a nursing home. Okay, well, if that's the case, Mom, I wonder if maybe we should go talk to somebody and see if we could get a plan together to make sure that doesn't happen.
Yeah.
Right? You've identified their concern, and now you're providing a solution to their concern. You're not telling them what to do. You're not coming in and saying, Mom, you need to go talk to a lawyer because you're going to get old and die.
Yeah, makes sense. People always can relate to stories or experiences. It's definitely, I can definitely see that. Well, John, we're just about out of time. Thank you for joining us today. You gave some great info on estate and elder law planning. How best can someone reach out to you, find out more about what you do?
Yeah, so we talk about this a lot on my Big Picture Retirement podcast. And if people have individual questions, feel free to reach out to me. My firm's name is Ross and Shoalmire. And our website is rossandscholmire.com, and you can go on there, and we've got all kinds of blog articles about estate planning and lots of information on there as well. So feel free, if you got a question, shoot me a message. Happy to answer it.
Great. We'll link to all that in the show notes. And thank you, everyone who tuned in to today's episode. Don't forget to follow the Agent of Wealth on the platform you listen to and leave us a review on the show. Thank you.
Thank you for listening to the Agent of Wealth podcast. Click the subscribe button below to be notified when new episodes become available. The information covered represents the views and opinions of the guests and does not necessarily represent the views or opinions of Bautis Financial. The content has been made available for informational and educational purposes only and is not intended to be a substitute for professional financial planning and investment advice. Always seek the advice of your financial advisor or other qualified financial service provider with any questions you may have regarding your investments and financial planning.